Hello, I'm Amanda Moore. I'm the director of the Clearinghouse Community. Welcome to the Advocacy Exchange for February 2018. The Advocacy Exchange is our monthly conversation with advocates advancing change. Both the Advocacy Exchange and the Clearinghouse Community are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. I'm happy to have with me today Carol Brooke. Carol is a senior staff attorney with the Workers' Rights Project at the North Carolina Justice Center, and she's joining us today from Raleigh, North Carolina. Hello, Carol.
Hello, thanks for having me.
We're glad that you're here. Carol's also the author of this month's Clearinghouse article. It's called Maintaining Options for Low-Income Workers, How to Defend Clients Against Non-Compete Agreements. And that's what we're going to talk about today. You can find Carol's article on the Clearinghouse Community, which is at povertylaw.org/clearinghouse. Well, we'd like you to be part of this conversation today, and I'll tell you how you can do that in a couple of ways. Those of you who are watching through the Shriver Center's YouTube channel on the live stream, you'll notice that beside the video, there's a box that says live chat, and you can send us questions, comments, anecdotes, whatever that way. If you want to go ahead and try it out, please do. You can just send us your name and where you're watching. We'd love to hear from you. If you'd rather not use the live chat, that's okay. You can also send me an email. I'll be keeping an eye on that while we're talking. My email address is Amanda Moore, M-O-O-R-E, at povertylaw.org. And I'll repeat that while we're talking, but you can send questions and comments that way as well. We would love to hear from you. A reminder that this is being recorded, and the recording will be available afterward on the Shriver Center's YouTube channel. Everyone who registered for today's webcast will get a follow-up email either tomorrow or early next week. It will have a link to the recording. It will have a link to Carol's article, and it will also have a link to register for next month's episode of the Advocacy Exchange. Oh, we've got someone saying hello. Hi, Claire in Colorado. Thanks for tuning in today. We're glad that you're here. Well, Carol, let's start and talk about non-compete agreements, and let's start with the basics. What is a non-compete agreement?
Well, a non-compete agreement is an agreement between an employer and an employee that puts restrictions on what that employee can do, either while they're still working for the employer or after they leave. Usually there's some sort of a time-limited aspect to a non-compete agreement, and usually the types of restrictions that are put on the employee would include the type of work that they can do, the type of employer they can work for, and where they can do the work. So you could have, for example, a dentist who, under the non-compete agreement, has agreed that he or she will not work as a dentist within 5 miles of the practice that they have just left for a period of 2 years, for example. And to be valid, a non-compete agreement has to meet certain requirements. So it has to be in writing. It has to be part of an employment contract. It needs to be based on consideration. It has to be reasonable as to time and territory, and it cannot violate public policy.
Got it. Thank you. So the example you gave is of a dentist. That's not our typical client and not who your article is about. So when these non-compete agreements are applied to low-income workers, why is that especially a problem?
Well, it's a problem both at the beginning when the non-compete agreement is entered into, and it's a problem during the employment relationship, and then it's a problem afterwards. At the beginning, a low-income worker probably does not have the bargaining power to try to negotiate the terms of a non-compete agreement the way a dentist or another high-skilled worker might be able to do to limit its impact. Then during the employment, if the worker wants to negotiate for a higher wage because perhaps they have a job opportunity elsewhere, that non-compete agreement could limit their ability to do that. So they could be stuck in this dead-end job because they know that they can't find a similar job after they leave. And then once they've left, of course, it could make it difficult to find another job. If there's a geographic restriction on that employee or former employee, they may not have the transportation they need to be able to go 10 miles away to find a similar low-wage job. So those are some examples of the ways it can impact you throughout the employment relationship and afterwards.
So, I mean, have you heard from clients who have had this happen where they've left and then they've actually sued by their former employer based on some sort of non-compete provision in their employment contract?
Yes, in fact, that's how I got interested in this issue. We represented a group of house cleaning workers who were sued by their former employer for violating a covenant not to compete and for lots of other things as well. And these were just simple house cleaners. They had no management position or any type of access to confidential information. They simply cleaned houses for the employer. And some of them, after leaving, began to clean houses on their own. Others did not, but they were all sued as a group, and we represented them. We've certainly heard from other legal services advocates that this is becoming more and more common in other low-wage professions like food service, and then in some of the more traditional professions like plumbing, carpentry, electrical wiring, things like that. It's becoming more common as well.
Well, we've had a question come in from David in New Jersey, and he asks if there's any precedent for arguing the reasonableness is in part related to the ability of the employee to be effectively self-employed.
That's an interesting question. I think the reasonableness usually looks at the actual parameters put on the employee in terms of the geographic region or the time period. But when you're arguing that a covenant not to compete violates public policy, I think you could bring in those types of things that you're talking about, that an unskilled worker may have very limited employment options, that one of their options is to be self-employed, and that if they can't do that because of the non-compete agreement, that it is an undue hardship. And that's, I think, how you would bring in that argument.
Thank you, David. Thanks for that question. So one thing that you stress in your article is the importance of the facts and gathering the facts. So let's say one of our viewers has someone come in who is facing this. What are the kinds of questions, what's the information that they need to gather just factually to be able to defend the client?
Well, of course, you're going to want to look at the language of the non-compete agreement and then compare it to the work that your client was doing at the time that they were working for the employer. So that helps you get at the issue of whether the non-compete agreement is overbroad. You're going to want to look at the geographic region where your client was working and see if the non-compete agreement restricts a greater area, for example. You want to know what customers your client was working for, if it's a customer service type job, and whether the non-compete agreement goes beyond that range of customers and restricts them from working for other customers of the employer, for example. Then you want to know more about the type of work that they were performing. Were they doing anything that gave them access to confidential information, to customer lists, to pricing or bidding information, anything that could bolster the employer's argument that that they have an interest in restricting the employee's ability to compete later. You also want to know a lot about the circumstances under which the non-compete agreement was signed. If it wasn't signed at the beginning of the employment relationship, was consideration provided? In our case, some of our clients were asked to sign the non-compete agreement after they had already been working for several years, and there was no additional consideration offered. And so at the outset, that invalidates the non-compete. And then, was it asked, were employees asked to sign it in retaliation for something else that they were asking for? Those are things that are pretty important. I would say the last really important factual issue is what your clients have been doing since they left the employer. Have they actually been engaging in any activity that could be seen as violating the non-compete, and what was that activity?
And so when you gather these facts, explain to us a little bit of the procedure here. So how do you take these facts and craft them into your defense? What are the arguments that you're using?
Well, I think I alluded to the sort of baseline issue is, was the non-compete agreement entered into properly? And if not, then that's your first defense, right? did your client actually violate it? Because if not, again, that kind of cuts things off at the pass. Was the agreement itself valid? Now that is going to be a pretty nuanced argument that you're going to have to make. You're going to have to look at the case law in your state and see what kinds of public policy arguments have prevailed in your state. What are the potential interests the employer could be saying that they have to advance through this non-compete agreement? What's the undue hardship that your client has suffered? Again, going back to, I think it was David's point that, for example, if the client is unable to start their own business as a result of the non-compete, is that an undue hardship that the court would think was valid? And then has the employer actually been injured? Has what your client done really caused them some sort of economic harm? Some of these things you get initially from the client, and some things you'll get in discovery, of course.
Understood. And I want to remind our viewers we would love to hear your questions for Carol. And we have one that just came in from Michael in Philadelphia. He asks if there's good case law to suggest that non-competes just cannot apply to low-wage, low-skill workers.
There are in some states, a lot of it is old, where cases, for instance, in North Carolina, there is some good case law that that dates back to the 1940s that looks at, the working man and what the working man needs to do to earn a living. In our case, I was not able to find a lot of recent case law, so I think you will probably be forging some new ground. But what may help that argument is that there are states that have looked at legislation where non-compete agreements could be restricted based on the income level of the employee. So low-wage workers shouldn't, suggesting that low-wage workers shouldn't, for some public policy reason, be subjected to these types of agreements. And in fact, there's also federal legislation that's been introduced that would also impose that kind of restriction, that anybody earning under $15 an hour, that a non-compete agreement would not be valid if it was applied to them.
Thanks for the question, Michael. And I'll remind all of you, we would love to hear your questions too. You can do that through the chat on YouTube. I know we've heard from one person who's having some trouble with that. You can also email your questions to me. It's Amanda Moore, Moore, at povertylaw.org. So we would love to hear from you. So Carol, you note that when employers go after their former employees, they often include other claims. So what sorts of claims should we kind of be on the lookout for or prepared for if our client comes in with a non-compete problem?
If you start looking at the cases on non-compete agreements, they almost always involve other claims as well. And so it's things like unfair and deceptive trade practices, civil conspiracy, tortious interference with contract, misappropriation of trade secrets. And a lot of the facts that you're going to need to develop for your non-compete argument will also be important to develop to counter these other claims that are probably going to be made. Another thing that you often see is when non-compete agreements are entered into, the client may also have signed a non-solicitation agreement, agreeing not to solicit the employer's customers. And they may have entered into a non-recruit agreement that they won't recruit the employer's employees. So they could also have claims related to breach of those agreements.
On the flip side of that, are there things that the client can do, sort of as can they bring any sort of counterclaims in the course of defending against a non-compete problem?
So that became key in the case that we worked on. Wage and hour counterclaims are the most obvious ones and the ones that you should really explore. I would do a really careful wage and hour intake and look for things like overtime violations, minimum wage, illegal deductions. I think it's worth looking at other employment-related claims that maybe couldn't be brought as counterclaims, but might add to your negotiating power in the case, like work injuries or discrimination. To the extent that your clients may have this lawsuit brought against them in retaliation for something they had complained about or taken action about when they were still working there. You could look at an NLRB charge as something that might make sense. One of the things that I learned in the course of this litigation was that even though some of our clients had worked at this company many years ago and the statute of limitations had long since passed for their Fair Labor Standards Act claims, that we were able to bring those claims in recoupment as counterclaims to offset any award that the employer could have gotten against our clients.
That's great to know. So are there any sort of non-litigation strategies that attorneys or advocates could employ if they have clients come in who have had this problem?
Well, I think media is always something to consider. Obviously, you have to keep an eye on the ethics rules and have an eye to your judge as well, and whether that might be problematic in your particular case. But certainly, there have been a couple of pretty well publicized large employers who have been kind of shamed into stopping this practice. Jimmy John's is one, and Amazon is another, where once the general public found out that sandwich makers and temporary packaging workers at Amazon were having to forego other employment opportunities, the outcry kind of stopped them in their tracks.
Great. Did you use media in the case that you've talked about?
We did not. We did not. We have talked about it afterwards, but during the litigation, we did not.
Gotcha. What about you? You kind of made reference to this a little bit earlier. What sorts of campaigns are going on right now, or efforts across the country to stop this on the front end? It kind of is getting at Michael's question. What do we know about that's going to try to limit the applicability of non-compete agreements to our clients?
So I mentioned that there is federal legislation, the MOVE Act. It stands for Mobility and Opportunity for Vulnerable Employees. That was introduced in June 2015, and I'm not sure how much momentum it has right now, but it would prevent non-compete agreements from being enforced against low-wage workers, and they have defined it there as being less than $15 an hour. And it would subject employers to a fine or civil penalty through U.S. Department of Labor. There are states that have banned non-compete agreements altogether. California, North Dakota, and Oklahoma are 3 states that I'm aware of.
That's a pretty wide range.
It is. It is. And I know that there's often a contrast drawn between California and Massachusetts, where they don't have similar restrictions, and looking at tech workers and how the tech industry has developed in California versus in Massachusetts. Courts, too, have put the brakes on these agreements in different ways. So in some states, a court will completely rewrite a non-compete agreement that they've decided is not properly drafted. In other states, they'll cut out the bad section and let the rest continue. And in some states, they'll say, well, if one part isn't valid, then the whole thing gets thrown out. So I think there's both legislative efforts, particularly around low-income workers, and then case law that is developing in good directions.
Well, can you tell us, you've talked about your case. I don't think you've told us yet, though, how it resolved. What happened with your case?
Yes. Well, we had some interesting legal developments. We had brought counterclaims, and we had to fight a motion to dismiss about the counterclaims, and were able to prevail on that. Eventually, we had a summary judgment decision that knocked out the non-compete claims against the people who had never actually signed the non-compete agreement, which you would think would be a no-brainer, but took a while to get to that point, and knocked out a bunch of the other claims, the ancillary claims. We were left eventually with a trade secrets claim, and then the non-compete claims against the clients who had signed the agreement, and then our counterclaims. We eventually did settle. And so the employer agreed to remove the non-compete agreement from future contracts, existing and future contracts, and to pay some back wages to some of our employees for back pay for unpaid travel time.
So this was a trade secrets claim against house cleaners, right?
It was. It sounds as ludicrous as it, I mean, it is as ludicrous as it sounds, I should say. Our clients worked cleaning houses in all the ways you would think that they worked. They had no access to any particular information, but there was a lot of back and forth about what constitutes a trade secret in the house cleaning business and what's generally known to anyone who has ever cleaned a house in their life.
That's really interesting. I'll remind our viewers, we would welcome your questions. You can submit them through the chat, the live chat on YouTube, or you can email me at Amanda Moore, MOORE, at povertylaw.org. One thing that I found really interesting in your article, you talk a lot about the public policy argument, that these go against public policy and different ways to make that. And one thing you said to look for was if the state has a right to work provision in law, which of course I always think of right to work provisions as being something that are harmful generally to working people. And so I thought it was interesting, kind of an interesting flip of that.
Yeah, I agree. It's not something that we had certainly ever argued affirmatively before, but in looking at our state's right to work law, there was some nice language, and in some cases, just about the importance of the mobility, people's ability to move from job to job, their right to earn a living. That seemed helpful. You know, ultimately, it wasn't really tested in our case. The court didn't rely on it in any way that we could tell, but I think it's worth, if you've got those statutes, taking a look and just seeing if that's something that can bolster your argument. I think there's a lot of hay that you can make about these sort of free market economic mobility philosophies that we are not used to touting in our work, but that courts might actually respond to.
I know another thing that you and I talked a little bit about during the course of your article and preparing for this was if we knew if there was a racial justice or a race equity angle to this. And, you know, because I was thinking that was something we definitely want to bring out, but it doesn't look like from our conversation that that's something that people have really examined yet at this point.
Right. I mean, I think it's an important issue for us to keep in mind, and certainly would love to see some research done on that. I think what we can say at this point is that to the extent that we know that low wage jobs are disproportionately held by people of color, clearly this issue is particularly important for people of color, but I have not seen anything that specifically looks at that connection.
So what are the other industries that you've heard of? So we've heard of the sandwich makers and house cleaners. What are some of the other low wage industries where these have popped up?
Yeah, so we interviewed a man who was a plumber who had signed a non-compete agreement and then eventually, many years later, left his job to work for another plumbing company, and was reminded that he had signed that non-compete agreement. And I think that we are seeing it in a lot of these sort of trade professions, plumbing, carpentry, electrical workers, where while they may not be considered unskilled workers, certainly they do have a level of training and skill. It's not skill that's unique to a particular employer. It's skill that's related to a profession in general. And so I think you would make similar arguments that there's no trade secrets, there's no confidential information, that the skills and training that the person has gained is what they would have gained for any employer, not this particular employer. And so while you can't maybe make the economic mobility or hardship arguments in quite the same way, I think a lot of the other arguments do apply to the skilled trades.
I want to shift gears just a little bit and ask you something more about your practice. So you're a senior staff attorney at the Workers' Rights Project there at the North Carolina Justice Center. Can you tell us a bit about what you focus on at the Workers' Rights Project?
Sure. Well, I mean, most of my work is litigation, and we do a lot of wage and hour litigation. We try to focus on impact cases, so we do a lot of class and collective actions. We will sometimes represent individual clients if we think that there's an important legal issue to move along. But we do a lot of work on behalf of farm workers. We've represented a number of house cleaners and janitorial workers at this point, restaurant workers, tipped wage issues, that kind of thing.
Gotcha. We've had a question come in from Amy. It's not really a question, more just a comment on the last point, that they are seeing these non-compete agreements with home health care workers who work for private agencies. They're trying to keep CNAs from leaving with patients. I'm not sure what a CNA is.
A certified nursing assistant?
Assistant, okay. From leaving with the patients.
That's a really interesting issue. I think in healthcare, there are some really good arguments to be made, and they have been made in the context of doctors who have had to sign non-compete agreements, that the relationship between a patient and the provider is important enough to sort of overcome the employer's interest in this case. And I think you could certainly make that argument with the home health aide. I think it's also ironic that home health workers are facing this type of thing now that they are entitled to overtime and minimum wage when working for a home healthcare company, because a lot of these companies have now gone to limiting people's hours so that they don't have to pay overtime. And so the need for a second job comes up even more in that instance.
That makes sense. Michael commented that in Pennsylvania, they have also seen these for home health aides, and notes that it appears to be a violation of Medicare and Medicaid laws.
Very interesting. Yeah, that's very interesting. I think there's a lot of policy angles to be explored with respect to home health aides and the new regs around minimum wage and overtime, and then non-compete, use of non-competes. That's really interesting.
For sure. Well, I want to thank you, Carol, for being with us today. And
thank you for having me.
You bet. And I want to remind people that there's a lot more detail available in your article, some citations to various statutes, cases. You can find Carol's article, Maintaining Options for Low-Income Workers, How to Defend Clients Against Non-Compete Agreements, at povertylaw.org/clearinghouse. And if you found today's conversation interesting and you'd like to be kept aware of when these are coming up, please join our mailing list. You can find it at connect.povertylaw.org/clearinghouse. And I'll remind you that the Advocacy Exchange is available as a podcast. You can subscribe to the Advocacy Exchange on Apple Podcasts or wherever you find your podcasts. And I'd like to invite you to join us for next month's Advocacy Exchange. My guest will be Abby Corsall. She's a senior attorney at the National Health Law Program. And we'll talk about the options that clients may have when the president issues a harmful executive directive. Our conversation will take place on Wednesday, March 14th, same time as today, 1 o'clock Eastern and 10 o'clock Pacific. And I hope that you will be able to join us next month. And until then, remember that you're not alone out there. Thanks very much.